Hello, everyone, and welcome to today's webinar, Advancing Information Sharing and Understanding the Information Blocking Regulations. My name is Rebecca Fien, and I am the ADA's Director of Coding and Dental Data Exchange, and I work within the Practice Institute. I'll be your host for today's webinar. Before we begin, I have a few housekeeping items to review. This webinar will be in listen-only mode. Any questions that you may have during the presentation or arise at the end can be submitted via the Q&A box at the bottom of your screen. Any technical questions, please use the chat box. We do expect today's presentation to take the majority of our hour. If there's time at the end, we will address selected questions from the Q&A. Any outstanding questions will be noted, and we'll work with today's presenter and the Office of the National Coordinator to provide and distribute additional information at a later date. At this time, it's my pleasure to introduce our presenter, Mr. Dan Healy. Dan joined the ONC as a policy coordinator in the Compliance and Administration branch of the ONC's Regulatory and Policy Affairs Division. Prior to joining the ONC, Dan worked as a senior researcher and analyst with healthcare system executives and their industry partners. Dan also has experience as a federal contractor working on training and implementation of clinical data standards and experience in state health policy and healthcare government affairs. Dan holds a master's in public policy from the University of Chicago. Dan, thank you for joining us, and we look forward to your presentation. Please go ahead.
Thanks very much, Rebecca, and thank you for having me. And good afternoon or good morning to everybody on the call. It's a pleasure to be with you today. As Rebecca mentioned, my name is Dan Healy, and I'm a policy coordinator in ONC's Office of Policy. I hope that we can be of service in providing you some more information about information blocking policy and regulations today. So with that, I'll review the agenda for today's presentation. I'll begin with some brief background on the Cures Act final rule and the information blocking regulations. Next, I'll walk through the regulatory definition of information blocking, and I'll highlight the various elements that make up that definition. I'll then walk through several of those elements in more detail, including things such as who are the information blocking actors, what is the knowledge standard that's set in the information blocking definition, what does the term required by law in the information blocking definition mean, what's the definition of EHI or electronic health information, and how does EHI fit into the definition of information blocking. What are some questions we can answer about information blocking enforcement? How to submit a claim of possible information blocking? And then lastly, I'll cover some of the information blocking exceptions and where to find more information. We have a lot of great resources on our website that are publicly available. I will try to, as I go, send some links to Corey to distribute in the chat. And I can also forward a list of those links with the slides following the presentation. And I'd also note that on the slides, there'll be links to various resources that I mentioned throughout the presentation that are available. So please don't feel like if you miss one of those in the chat, that you've missed it. They'll be available with the slides and following the presentation as well. So with that, let's get started. Okay, so to begin, this is our standard legal disclaimer slide, which means what I want to tell you that what we're discussing here today and the text on these slides are for your informational purposes only. While you can read the slide, the main takeaway is we'll try our best today to present accurate information, but sometimes we misspeak. So please remember that the official provisions and requirements for information blocking can be found in the regulatory text at 45 CFR Part 171. So to sum up, I am not a lawyer. My words are not legal advice. And the regulatory text always controls. So if there is any discrepancy between something that I say, the regulatory text is ultimately what controls. In addition, I will try to leave some time for questions at the end. I will see how much time we have left. In terms of questions, one thing I wanted to note is that we're not able to speak to fact-specific what-if type questions because we don't have the authority to give what's called advisory opinions. And that means we don't have the authority to tell you how the law applies to proposed facts before you act. And we also can't speak on behalf of other HHS departments like the Office of Civil Rights or the Office of Inspector General, who I may mention as I go through the rest of the presentation. For more info on advisory opinion authority and ONC's request for that, our Deputy National Coordinator, Steve Posnack, wrote a blog post detailing ONC's request for that authority, and that's available on our website at healthit.gov if you go to our blog page there. All right, so now I think we can move to the next slide. Okay, so here I have the definition of information blocking from 45 CFR 171-103 here. Before I walk through the definition and note the elements that make up the definition, I'd like to start with some brief background on the 21st Century Cures Act and the Cures Act Final Rule. So in 2016, the 21st Century Cures Act, or just the Cures Act for short, which contained the information blocking statute, was signed into law. To fulfill HHS's regulatory responsibility under the Cures Act, ONC published a proposed rule in March 2019 and a final rule in May 2020, which has a longer title, but I'll just refer to it as the Cures Act Final Rule. The applicability date for the information blocking provisions in the Cures Act Final Rule was April 5th, 2021. So this date had been moved forward from the original applicability date of November 2nd, 2020. So with that, let's now take a look at the information blocking definition that we see here on the screen and the various elements that make up the definition. So walking through the definition initially, and then I'll go into more detail into the various elements of the definition here. But to walk through the definition initially, we have information blocking means a practice, and a practice is defined as an act or omission that, except as required by law or covered by an exception, is likely to interfere with, and we see the definition of interference here on the bottom right corner of the slide, to prevent, materially discourage, or otherwise inhibit access, exchange, or use of electronic health information, or EHI. So there, with the first paragraph there, we've kind of covered the first 4 elements of information blocking that we see on the checklist on the right of the slide here. And I'll talk more about what some of those specific phrases mean as we go through the presentation. So next we have, if that practice is conducted by a health information technology developer of certified health IT, a health information network, or health information exchange. So these are the categories of information blocking actors who are regulated by the information blocking provisions. Such developer, network, or exchange knows or should know that the practice is likely to interfere with access, exchange, or use of EHI. So there in the second part, we see one category of actors and one standard for those actors. So we see health IT developers or certified health IT, health information networks, and health information exchanges. And we see that the bolded text knows or should know. Then in the third paragraph here, we have if conducted by a healthcare provider, such provider knows that such practice is unreasonable and is likely to interfere with access, exchange, or use of EHI. So here we have another category of actor, a health IT, a healthcare provider. And we see that the standard there is knows rather than knows or should know. So I'll note that, and I'll come back to that later as well. So with that, we've now talked about the last 2 elements of information blocking that we have on the checklist on the right. So that the practice was conducted by an information blocking actor, and that the actor has the requisite knowledge that we see here, that they meet that requisite knowledge standard. And then lastly, letter B at the bottom, we see that the for purposes of information blocking, the electronic health information that's in scope for information blocking was limited to just the EHI that is identified by the standard noted here, the US CDI V1 standard. That was prior to October 6, 2022. So now that we're past that date, all EHI is in scope for information blocking. And we'll talk a little bit more about the definition of EHI and what that means as we go through. So I like to kind of start there with the full definition, and we can go into different parts later on. But I think it's helpful to sort of ground our thinking there. One additional note that I would mention here in terms of a question that I know has come up sometimes, and I believe has come up for this group, relates to a question that we have in an FAQ on our website. So the FAQ, the question in the FAQ is, do the information blocking regulations require actors to have or use certified health IT or upgrade the certified health IT they already have in order to fulfill a request to access, exchange, or use electronic health information? And the answer to that we have on the for that FAQ that we have on our website is no. The information blocking regulations do not require actors to have or use health IT certified under the ONC Health IT certification program. actors sort of subject to the information blocking regulations are not required to immediately upgrade their certified health IT if they also happen to participate in a separate regulatory program that requires the use of certified health IT, such as CMS is promoting interoperability programs. And I will send the link to that specific FAQ so that we can put it in the chat if folks want to take a look at that specific link there. Okay, so having talked about the IB definition as a whole, let's now move and look at some specific elements of the definition. So first one I have here is required by law. So as we saw on the slide before, one element of the information blocking definition is that the practice must not be required by law. So if a practice is required by law, then it can't meet the definition of information blocking. So I'd pause here to highlight, for example, that disclosures of protected health information, for example, that are not permitted under the HIPAA privacy rule remain not permitted, for example. So as the first bullet says, this is specific to interferences with access, exchange, or use of electronic health information that are explicitly required by state or federal law. So I'd highlight the words specifically and explicitly there. We're talking about practices that are specifically required by state or federal law, which I would differentiate between that and practices that are, for example, permitted, but maybe not required. So here we're just talking about practices that are required by law. And if one of those practices is required by law, then the practice would not be able to meet the information blocking definition, because it wouldn't satisfy all of the elements that we saw in the previous slide that make up the information blocking definition. And below in the box on the lower part of the slide, we can see some clarification in terms of what we mean when we say federal and state law, what that includes. So we can see there that it includes things like statutes, regulations, court orders, and binding administrative decisions or settlements, such as those from FTC or the EEOC. I'll also touch on this specifically in relation to the privacy exception, which I hope to cover later in the presentation as well. And while we're on this topic as well, I also have some links to additional FAQs that are available on our website that involve questions related to state and federal laws. So I've pulled these from our page, and we'll send those to hopefully add to the chat as well. I'd also note that if you all of these are also available on our website at healthit.gov/FAQs, or you can also go to healthit.gov and go to our information blocking page, which is in one of the drop-down menus at the top of the page there. Okay, so let's move on to one of the other elements of information blocking, which is the practice must be done by an information blocking actor. So as we noted, there are three kinds of information blocking actors: healthcare providers, health IT developers of certified health IT, and health information networks and health information exchanges. So first, and I think perhaps of most interest to our group today, we have healthcare providers. Healthcare provider, the definition of a healthcare provider is defined in the Public Health Service Act. So I would point you to our website for the links if you want to look at the full definition of how a healthcare provider is defined in the Act. We also have some fact sheets that I will also add to the chat here that provides some more information on the types of entities that make up the healthcare provider definition. So second, we have health IT developers of certified health IT. This term is defined in the information blocking regulation, and it means individuals or entities, except for a healthcare provider that self-develops health IT for their own use, that develop or offer health IT, and at the time in which they engage in a practice that's the subject of an information blocking claim, have one or more of those health IT modules certified under the ONC Health IT certification program. And then third, we have health information networks and health information exchanges. So the definition of health information networks and health information exchanges, or HINs and HIEs, is a functional definition, and it generally rests on two things. The first is that the entity allows promotes access, exchange, or use of EHI among more than two unaffiliated individuals or entities other than the HIE or HIN itself. And then the second is that access, exchange, or use of EHI or electronic health information is for a treatment, payment, or operations, healthcare operations purpose. So having gone through the three categories of actors here to which the information blocking regulations apply, I note a couple things. The first is that none of these definitions depend on whether those actors are, for example, covered by HIPAA or are business associates of a covered entity, or are, for example, eligible to participate in any particular program. I'd also, again, note a couple of the fact sheets that we have available, and I'll try to forward those as well in case they're useful for looking at how the information blocking actors are defined here. And while we're on the subject of information blocking actors, one related topic that I wanted to touch on is what I call the knowledge standard element of information blocking. So this slide describes the knowledge standard required by any actor. And so as you can note here, there's a difference in the knowledge standard between types of information blocking actors. So for healthcare providers, the knowledge standard is knows that such practice is unreasonable and is likely to interfere with the access, exchange, or use of electronic health information. And for the other two types of actors, health IT developers and health information networks and health information exchanges, the knowledge standard is knows or should know that such practice is likely to interfere with access, exchange, or use of electronic health information. So I wanted to note that as well, while we're on the subject of information blocking actors, and note the difference in knowledge standard there that applies to different types of actors, depending on what type of actor one is. Okay, so now I'm going to spend a couple slides looking at the definition of EHI, or electronic health information. That's another one of the elements of information blocking in our checklist. So I'll start with the definition here, and then continue on with some additional points in the following slide. So as we see here, EHI, or electronic health information, is any electronic protected health information, or EPHI, to the extent that that EPHI would be included in a designated record set, as those terms are defined for HIPAA. So both of those terms, designated record set and EPHI, are defined under HIPAA and used the same way here. So the information we talk about when we talk about EHI is the same information that an individual or their personal representative has a right to access under the HIPAA privacy rule. It's the electronic portion of that information. So a couple other points I'd mention here. In the second bullet, we see that psychotherapy notes and information that's compiled for certain other proceedings are not part of the EHI definition. Also, the definition of EHI is applicable whether or not that information is held by or for a HIPAA-covered entity. So the definition of EHI, as we see, depends on the information itself. It's not contingent on whether that information is held by or for a HIPAA-covered entity. And also, the definition doesn't limit EHI to what's recorded or exchanged consistent with any specific interoperability standard. So I just wanted to note that as well. And then lastly, again, the information we're talking about when we talk about EHI is health information that an actor has electronically. So paper records and the like are not within the definition of EHI. Here, we're only looking at electronic health information. Okay, so now that we've taken a look at the EHI definition in its entirety, I wanted to take a look at one of the EHI related resources we have available, our Understanding EHI fact sheet, which you can see a screenshot of on the left here. So what you see here is page 2 of the fact sheet. It's a checklist that I hope is helpful in understanding what information would be considered EHI. So we have the EHI definition at the top, and then a checklist to sort of run through the definition and examine a little bit each of the individual terms that make up that definition. So if you have information that's individually identifiable health information, and on the checklist that is hyperlinked to the definition of that phrase there, that's maintained or transmitted by electronic media and would be included in one of the following groups of records that we see here, bulleted here, which include medical records and billing records of a provider about individuals, among others. And that information is not excluded from the EHI definition. So it's not one of the bullets at the bottom here of things that are excluded from the EHI definition, like, as we mentioned, psychotherapy notes or information that's compiled for certain purposes, like certain administrative actions or other information that's identified there. If the information meets those requirements and it's not information that's excluded from the definition, then it would be EHI. And on the right, we have some links to other resources, which include blogs, as well as an infographic that takes a look at this same information, but in a more graphical form, as well as some EHI specific FAQs and previously recorded webinars. And I will forward the links to those as well, and see if we can put these in the chat as well. Apologies, it's my hyperlink isn't working there, but these are linked on the slides as well, so we'll have those available. I'd also, while we're on the topic, like to highlight a couple of EHI related highlights from our Deputy National Coordinator Steve Posnack's blog, titled 8 Regulatory Reminders for October 6th, which is linked here in the additional EHI resources. And so I'm just going to read a couple of the bullets from Steve's blog here, because I think they're a great explanation of some of the questions that around EHI. So to put it simply, the same electronic protected health information, or EPHI, that an individual has a right to access and request an amendment to under the HIPAA privacy rule is the same EPHI that we're talking about here with information blocking. And importantly, the information blocking regulations apply not only to practices associated with individuals seeking access to their own EHI, but also to an information blocking actor's practices associated with its business-to-business relationships as well. If those business-to-business relationships are among or between information blocking actors. So an IB actor's existing efforts to meet the HIPAA privacy rule requirements puts them on solid ground when it comes to understanding EHI, where it may reside, and whether and how complicated it may be to make EHI available for access, exchange, or use for purposes of the information blocking regulations. So I wanted to note that from Steve's blog there. And I would encourage folks, if they want to read that, because I think it's while it came out a couple months ago, I think it still contains a lot of really useful information when it comes to EHI and a lot of the questions that folks may have on EHI and how it fits into the information blocking definition there. Okay. So next, I'd like to move to broadly what I'd call the compliance and enforcement area of the information blocking regulations. The Cures Act prescribes penalties for information blocking, which are shown here. So for one set of actors, the health IT developers of certified health IT and health information networks and health information exchanges are subject to civil monetary penalties or CMPs of up to $1 million per violation. In addition, health IT developers of certified health IT can also face certification actions, which could include a certification termination or ban. For health IT, or excuse me, for healthcare providers, HHS must engage in rulemaking to establish appropriate disincentives as directed by the 21st Century Cures Act. And I'd also note, as we note at the bottom, we see that enforcement dates for civil monetary penalties will be established by current rulemaking by the HHS Office of Inspector General, and appropriate disincentives are to be established by future HHS rulemaking. And if folks are interested in seeing information about regulations, they can go to reginfo.gov for the unified agenda, which will list regulations there if folks want to see more information on that. So one question we sometimes receive is, what happens when a claim of possible information blocking is submitted to ONC's report information blocking portal? And we've created a diagram for that process that you can see here, that's accessible on our website as one of our fact sheets. And I can forward the link to that as well. I won't go through the whole flow chart as you can see it here, but I just note or highlight, one highlight I'd make is that we can see the scope of authorities that are described here for ONC and OIG, the HHS Office of Inspector General. So ONC has the authority to investigate and take action under the ONC Health IT certification program for health IT developers of certified health IT. And OIG, or the Office of Inspector General, has authority to investigate all types of information blocking actors, and that includes also health IT developers of certified health IT, but as well as the other types of information blocking actors that that we mentioned earlier in the presentation. One other question that folks may have that goes along with what we have on the slide here is how a claim or report of possible information blocking would be evaluated, and we have an FAQ on that I will forward for the chat as well. And I'll just note the response or the answer to that question that we have published as an FAQ here. So we note that the facts and circumstances of each situation or allegation would need to be evaluated. Whether a practice constitutes information blocking depends on the unique facts and circumstances of the practice. More specifically, information blocking occurs when an individual or entity engaging in the practice is an actor, as defined in the information blocking regulations. The practice involves EHI, as defined in the information blocking regulations. The actor meets the requisite knowledge standard that applies to the type of actor they are, and that the practice is likely to prevent, materially discourage, or otherwise inhibit the access, exchange, or use of EHI. The practice is not required by law, and it's also not required, or excuse me, not covered by an exception. So that, I would say kind of echoes the checklist that we sort of went through of the elements of the information blocking definition at the beginning of the presentation there. One additional note I'd make on this information when we are talking about claims of information blocking of possible information blocking that are submitted to ONC is that any information received by ONC in connection with a claim or suggestion of possible information blocking, and that could be reasonably expected to facilitate the identification of the source of the information, so the claimant, that information is protected from disclosure under the Cures Act. So I would just note that here as well, while we are on the subject of claims of possible information blocking. And then lastly, on this subject, we do update our statistics on information blocking on a monthly basis, and that information is also available on our website at healthit.gov. If you go to healthit.gov and go to data and then quick stats, that information is updated on a monthly basis on our website there. Okay, so now that we've walked through the various elements of the information blocking definition, I wanted to circle back to this slide to just review what we've discussed, and because I like this slide as sort of a helpful way to organize our thinking. So for practice to meet the definition of information blocking, it would have to check all the boxes or meet all the elements that you see here. So we've talked about the first 5 that you see here so far. So actors, electronic health information, interference, the knowledge standard that's required of an actor, and what it means when we say not required by law. And then the last one here we can see is not covered by an exception. So for the next part of the presentation, I will shift a little bit to talk more about some of the information blocking exceptions. Okay, so here we have the exceptions themselves. There are currently 8 exceptions to information blocking. And an exception means that if an actor's practice is likely to fit the definition of information blocking, the exceptions cover situations where if all the provisions of an exception are met, that practice will not be considered information blocking. So I won't have time to cover all the exceptions in detail here, but I'll just note, I'll note a couple things. The first is that the exceptions are voluntary, so actors are not required to claim an exception. And the second, as we see here, is that the exceptions are grouped into 2 broad categories. One of those involving not fulfilling requests to access, exchange, or use electronic health information, and the other involving procedures for fulfilling requests to access, exchange, or use electronic health information. And we do have a fact sheet as well on the exceptions, which I will put in the to hopefully put in the chat here as well. So let me jump into a couple of the exceptions and talk through them. So the first exception I'll cover here is the content and manner exception. So the content and manner exception is one of the exceptions that addresses procedures for fulfilling requests to access, exchange, and use electronic health information. It covers instances where an actor may limit the content of its response to a request, and or where an actor may provide the electronic health information, but in a different manner than it was requested. Like all the other exceptions, for this one to cover a practice that would, excuse me, otherwise be considered information blocking, all the conditions of the exception have to be met at all relevant times, which in this case means one would have to meet the content condition and the manner condition. So let's look at those two conditions. I'll look at the content condition first here. Okay, so here we have the content condition, and I will focus on the second bullet here because we're after October 6, 2022. So an actor must respond to a request to access, exchange, or use EHI with the EHI as it's defined in 171.102. So again, we're going back to the definition of EHI that we covered earlier in the presentation. And we're saying that the actor must respond to the request for access, exchange, or use with the information that meets that definition of EHI. A couple points of interest here. This can be met if the actor does not have all of the requested EHI. It also does not require that EHI be held in or shared using specific technology or particular technical standards. And it can be met where some EHI is withheld due to other laws or is permissible to be withheld, such as under some other exceptions, such as the preventing harm or the privacy exception. So we touched on the content condition. Now let's look at the manner condition. And here we're talking about how an actor goes about fulfilling a request to access, exchange, or use EHI. So to start with here, we have an actor must fulfill a request in any manner requested. So if an actor fulfills a request in any manner requested, then the actor's practice is not subject to the fees or licensing exceptions. So that's the first part of the manner condition I'd highlight here. The actor must fulfill the request in any manner requested unless the actor is number one, technically unable to fulfill the request in a manner requested, or number two, the actor cannot reach agreeable terms with the requester to fulfill the request. So these exceptions deal with the terms for access, exchange, and use of EHI. I would note that they deal with the terms, not with the EHI itself. And I would also just note that, again, first, the actors must fulfill the request in any manner requested, unless they are technically unable or they can't reach agreeable terms with the requester. So if an actor responds in an alternative manner, then the actor must fulfill the request without unnecessary delay in the following order of priority. So working down from 1 to 3 here, we have first using technology that's certified to standards adopted in Part 170 that's specified by the requester. Next, we have using content and transport standards specified by the requester and published by the federal government or a standards organization like the American National Standards Institute. And then lastly, third, we have using an alternative machine readable format, including the means to interpret that electronic health information that's agreed upon with the requester. So this basically delineates the order of priority in which the actor must fulfill the request if they're fulfilling the request in an alternative manner. Okay, so we briefly mentioned the fees exception. So let's talk about that here. I know we're short on time. So the fees exception states that it will not be information blocking for an actor to charge fees, including fees that result in a reasonable profit margin for accessing, exchanging, or using EHI, provided that certain conditions are met. So to qualify for the fees exception, there's a three-step process. The actor's practice of charging fees must, number one, meet the basis for the fees condition. Number two, it must not include any fees that are specifically excluded. And then number three, this would apply if you are a health IT developer that's subject to the conditions of certification for ONC's health IT certification program. If you are, then you would have to comply with certain of those conditions, like the assurances or the API condition of certification, if that applies to you. I'll include a link to the fees exception, the regulatory text of the fees exception, along with our fact sheet on the information blocking exceptions. If folks are interested to learn more about that, to go through the specific elements of that, as I won't have time to cover all those here, but I'll include the link there. Next, we have the infeasibility exception. So this exception states that it will not be information blocking if an actor does not fulfill a request to access, exchange, or use EHI due to the infeasibility of the request, provided that certain conditions are met. So to satisfy this exception, excuse me, the actor's practice must meet one of the following three conditions. And we have those three there in the yellow box. So the first is uncontrollable events. So the actor cannot fulfill the request for access, exchange, or use of electronic health information, for example, because of an uncontrollable event, and some of the events that are listed there. And again, I'll put the link to the regulatory text here in the chat, but some of the events that are listed, for example, are a natural or human-made disaster, public health emergency, public safety incident, terrorist attack, and other events. The second category there we see is segmentation. So segmentation is because the actor cannot unambiguously segment the requested electronic health information from other electronic health information that either cannot be made available due to an individual's preference, or because that information can't be made available by law, or because that information may be withheld in accordance with the preventing harm exception. And then third is infeasible under the circumstances. So that is the actor demonstrates that prior to responding to the request, as we can see below, within 10 business days of receipt, the actor must respond with a written response of why the request is infeasible. And there are various elements or things that have to be part of that written response that are in the regulatory text that is in the link below there. Okay, I will try to cover a couple here. I know we're coming up on time. So next is the privacy exception. So this exception addresses practices that interfere with access, exchange, or use of EHI in order to protect an individual's privacy, provided that certain conditions are met. So here that means one of the below 4 sub-exceptions has to be met, and all the conditions within that sub-exception have to be met. So because we're coming up on time, I will try to focus just on 2 parts of the sub-exceptions here. So first here we have precondition not satisfied. So that sub-exception means that before electronic health information can be accessed, exchanged, or used, federal or state law requires that some other condition be satisfied. So this exception could be used when a state or federal law requires some sort of extra step before EHI can be accessed, exchanged, or used. For example, many states have identification verification laws where the actor tries to verify the identity of the requester. In letter E here at the bottom, we have respecting an individual's request not to share information. So this exception states that unless otherwise required by law, an actor may elect not to provide access, exchange, or use of an individual's electronic health information in order to protect an individual's privacy if several requirements are met. And I won't go through all the requirements here, but I'll just highlight them. I'll highlight a couple of them and note that folks can also check out the link to the privacy exception there if they want to view all the requirements. But those requirements include the individual requests that the actor not provide such access, exchange, or use of EHI. And that request is not influenced by any improper encouragement or inducement of the request by the actor. The actor documents that request within a reasonable time period, and the actor's practice is implemented in a consistent and non-discriminatory manner. One note I would make on this sub-exception of the privacy exception is that it states that an actor may elect not to provide access, exchange, or use of an individual's electronic health information unless otherwise required by law. So, for example, a patient's request could not override, for example, a legally mandated public health case report here. Okay, I know we're coming up on time, so I'll briefly touch on the security exception here before we wrap up. So the security exception states that it will not be information blocking for an actor to interfere with access, exchange, or use of EHI in order to protect the security of EHI, provided that certain conditions are met. And I won't go through all those here, but I'll also include the link to the regulatory text of the security exception here in the chat to note if folks want to learn more there. As well as I would again recommend our fact sheet on the information blocking exceptions, which goes through all of the exceptions and has some useful information there with regards to the individual parts of each of those. And then here I've included some links where to find more information for various topics. This will be distributed with the slides along with the other links. Just a couple notes that I would make here. We do have previous webinars that are recorded that are accessible at this link. We also include the link here for submitting reports of potential information blocking. And then we also include a link here to our Health IT feedback and inquiry portal, where anybody can submit a question to us through that portal if they have questions, and we will do our best to answer it. I would also really encourage everybody to sign up for our weekly newsletter at healthit.gov. That way you'll receive updates when we have events or other things coming up on the calendar. It's a great way to stay informed, and I would again really encourage everybody to sign up for that if you're interested. And we also have some contact information here. So I know we are a little over time. I will pause here and hand it back to Rebecca to wrap up, and maybe just do a quick check on the Q&A. But Rebecca, I will pause here and hand it back to you.
Thank you so much. As Daniel indicated, we'll make sure that this presentation and all the resources that are shared are sent out and made available to you. We do encourage you also to check out the ADA resources on information blocking that were just posted to the chat. Daniel, on behalf of the ADA and our membership, I want to thank you and the ONC for this presentation. And we hope to continue a partnership where we can continue to bring this type of information to our audience. So thank you, and thank you to everyone who joined us today.